Understanding the structure of hospital governance and the power of the medical executive committee is essential for any practicing physician. In California, hospitals operate under a dual structure system. On one side, you have the administrative governing body overseeing daily operations. On the other, you have the medical staff. As established in the Elatar and Natarajan cases, the medical staff is actually a separate legal entity from the hospital itself. It is the medical staff that holds the primary responsibility for the adequacy and quality of medical care provided to patients. Under Business and Professions Code Section 2282.5, the medical staff maintains the right of self-governance. This includes setting standards for membership, managing quality assurance, and adopting the bylaws that govern your professional life. While these bylaws are subject to the approval of the hospital board, that approval cannot be unreasonably withheld. For the individual doctor, this creates a complex web of overlapping authorities between hospital boards, medical staff bylaws, and state regulations. It is often unclear who truly has the power to regulate your conduct or supervise patient safety. This confusion can become a significant liability when professional disputes arise. One of the most critical areas of concern is the trigger for reporting to the medical board under Section 805. Most physicians don't consider these rules until a crisis is already underway. The state of California uses a specific reporting form with 11 primary triggers divided into two main categories. The first category involves actions taken for a medical disciplinary cause or reason. This includes the termination, revocation, or denial of staff privileges, membership, or employment. The second category involves restrictions that last for a cumulative total of 30 days or more within a 12-month period. This covers restrictions on privileges, membership, or employment, whether those restrictions were imposed by the hospital or voluntarily accepted by the physician. The ambiguity in these triggers is where the danger lies. For example, the term restrictions on employment is notoriously vague. Does a restriction born from a personality conflict count? If you apply to perform a new hospital procedure and are turned down, does that constitute a reportable denial of privileges? Often, a hospital may not even realize an action is reportable until their legal counsel reviews the file. By then, the process may have escalated beyond your control. Our medical legal group strongly recommends seeking expert advice during these gray area events. Early intervention allows for negotiation with medical executive committee lawyers. In many cases, experienced legal counsel can limit or supplement the contents of an 805 report to be more favorable to your record. Navigating these self-contradictory spheres of power requires a dedicated defense to protect your medical license and your professional future. If you need legal help, call us at 925-283-1863. Call us at 925-283-1863. Protect your medical career today.